right, and our first item after the break was S 8553. We have Michelle Childs here with a amendment. Assume it's a strike all since it's such a short bill. We have that? Peggy, did you give that to us and I didn't?
Yeah, right there.
Oh, okay. It is,
I had it, now it's not.
yeah, but no, I don't have,
New packet. That's it, right?
Oh, here we go. I got it.
all right. So it's too bad we. Okay, I've got it. It's 553. All right, the amendment. 553?
Yes, 553.
Are we doing, we're doing cannabis first, or we're doing 553 first?
553 first.
Oh, okay.
Yes.
That's how I have it on the agenda. Okay, so basically, striking out, you're amending it by striking out prohibited from legally marrying one another and inserting thereof not be related by blood closer than would bar marriage under state law.
I haven't heard anything about it.
Correct. And so
That's
that's how it's phrased from State of Vermont HR. So I just used that language.
Jen, do you want to comment on that or are you fine?
Yeah, no, I don't think there is.
I'll just comment that the center supports the language. Jennifer Pullman, for the record, the Vermont Center for Crime Victim Services. We had not in the original bill proposed a definition, and we appreciate that this body has decided to try and figure out what that should look like. But we support the amendment and appreciate the committee's time.
Okay. So, is there a motion to to amend H553 as seen in draft 1.1? Yes.
Not for me.
Senator Baruth has moved that we report that we amend H553 as seen on draft 1.1.
Yes. So, wait, we need to start one. It's almost second.
No, I don't need it.
I mean, I'm opposed to it because of the 6 months. You only have to be together for 6 months and then you would be eligible for this. I think that's too short a time really to be so committed. And I think that as we heard, the fines are not making enough money for their needs, and therefore, they're having a tough time. And to put more people into it, it's not going to be very many, of course, but still to be expanding it at a time when they're not getting the money they need from the sources, and that only 6 months is just beyond me.
Senator Nika, if it might be helpful, just that this only makes establishes the person's eligible to file a claim. It doesn't mean that their claim is approved. So we do have claim specialists who require verification, who go through sort of an investigative process, let's say, where there's a back and forth that does establish it. So it just makes them eligible to even file, but it doesn't mean that they are in any way, automatically then having that piece that it's not an entitlement. It just makes them eligible to be able to apply. And then the other piece is just with respect to domestic partners now in current language, we can cover mental health counseling expenses, and that if we were to change the definition to a year, that would change how we could cover the mental health piece. But we do have a very robust process for looking at claims and, asking for receipts, asking for proof, asking for that piece. So I don't know if that helps to make you feel any better about it, but that is a piece that it's not just you get this money, it is you're eligible to even file.
think the fact that it's rather misleading to make somebody believe that they will get it when they say they can file and then it will be evaluated. I think obviously most people would get through the evaluation. So I think that I still am, I'm fine with the new language, that's not a problem, but I'm not fine with the 6 months. That's too short of time. And your money situation is also in a difficult time right now, so.
Any other comments? Peggy, would you please call?
Actually, if I could just ask, Jen, could you repeat and clarify the part about if you changed it to a year, what problem that would introduce on healthcare?
Sure. Currently, we have our own internal policy that defines domestic partner, which we took a couple of pieces from the HR definition to help guide us. And our board approves all of our policies. They're transparent. They're on our website. And currently, we are able to provide coverage for mental health expenses per definition of victim in subsection 7. And if we changed the definition of domestic partner to a year, that would change what we currently can do in terms of supporting mental health counseling for domestic partners. So of course, it's a policy decision. Again, we do vet our process through our board, which is created in statute, and all of our policies are online through our website. So that would just be something that we would have to take into consideration. Appreciate this body's concern for our budget. We certainly, being the ones who are in this seat, share that concern. This would at maximum be based on our prior cases. At the very most egregious situation, maybe $6,000 out of our fund, which does get reimbursed at 75% from the federal fund.
Thank you.
May I ask a question? The 6 months is the time that HR uses for state employees for people to be eligible for health care for domestic partners, is that right? Okay.
Yes, we weren't able to find any definition anywhere else.
Okay.
Thank you. So, the amendment. Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes, we're on the amendment only.
Yeah.
Yes.
Senator White.
Yeah.
Senator Baruch,
Yes.
Senator Sears.
Yes. All right. Now, is there a motion to report favorably H 553 as amended? For the purpose of the discussion, I will move that we report H 553 as amended. Is there any discussion?
Nope. I am still going to vote for the bill, but Alice convinced me not to move it.
Okay. Is there any further discussion? Peggy, did you have something you need?
No, I'll vote first and then.
All right, Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
No.
Senator White,
Yes.
Senator Baruch,
Yes.
Senator Sears.
Yes. Who would like to report this besides Senator Nick?
Not me.
All right.
So Jen, I would like to say I certainly support the program.
Senator Sears.
I guess.
I think you're doing a great job, but I had to do this, but you are doing very good work there.
You have a copy for me to sign.
Thank you, Senator. And I know, Senator, that you support us, and I appreciate your concern. And this is one of those ones that not.
Let's shift our attention.
We're thinking right now, as you know, Senator. So thank you for your support, and I recognize that you have always been at the center.
Yes, thank you.
Let's move to the simple little bill.
Let's move
next
to
time,
the.
next time there is a simple little bill, Jen, okay?
Let's move to the less
I've learned.
controversial bill. Miscellaneous cannabis establishment procedures, H 548.
It is amazing how many times people invoke that And they say, I know you should never
Yeah.
say it.
They do it anyway.
But then they do it.
Turns out.
Hold up. All right, this is not a simple little bill. It started out with technical amendments. Can you, we should have a copy of.
Yep, I do. You should all have a copy. Yep,
Page 548, and this copy here.
correct.
So you want to go through that, Michelle?
Sure. Would you like me to share the screen? Or prefer
Yeah, why
not?
don't you, because that way Pepper can see
Yeah.
it, and anybody else who's.
Okay, so we are looking at draft 1.2 of an amendment to H 548. And I've tried to highlight the language, the new language. So starting in section 1 in the definition section, the first one is related to the child deterrent packaging, and this is in 2 places. So back in a little bit later, then we'll look at the provision that talks about whether or not whether or not flour needed to be in child resistant packaging, and I think where you settled was James had suggested a little lesser standard than using the federal standard for child resistant and using child deterrent. So this is the definition that he offered for your consideration. So it's added to the definition section.
You could have just compared it to cat food containers these days.
I just wanted to say I appreciate that definition. So Pepper, if you're listening, I think that squares the circle.
Okay,
Okay, the next one is on page 3. There is a new definition of owner that's currently not a definition that is in the chapter with regard to who is an owner with respect to who is a licensee. And I'm just gonna, if it's okay, I'm just gonna kind of boot some of these questions around because this is related to the FBI look at the records, and I'm gonna kind of shift that over to James because I haven't been intimately involved necessarily in how CCB is proposing that they address that issue. Related to that is also the change to the definition of principal, which is subdivision 27, and that's at the bottom of page 3. And so one of the issues, and I'm sure James can talk about it, but that in talking with David Scher and Bryn about it was that the FBI wanted there to be definitions of president, vice president, things like that. And so basically this is just cross-referencing those terms as they're used in the cannabis establishment chapter with those that are used elsewhere in our corporations law. So there's no changes to section 2. Section 3 is new to your version, but this is the
Michelle?
section with, I'm sorry.
Sorry, before we leave that last section, it's fair to say that this is all existing law and definition elsewhere in our statutes?
You mean the references to
Well,
title,
the
to title 12
definitions-
around for principal?
Yeah,
Yes, it's cross-referencing existing definitions. I mean, it doesn't always necessarily match up, and there's not always kind of one-for-one definitions, but yes, it's referring to the definitions of those terms as used in our corporations law and our current titles.
okay, thank you.
So section 3 on page 5, this is adding in the amendments to prohibited products that were in the bills as introduced in both the House and the Senate, was removed by House Government Operations. And this is, you'll see the language there on of products that are currently prohibited in the commercial market. So this is just dealing with licensed cannabis establishments and not with dispensaries. And you'll see this is striking out On lines 17 through 20, subdivisions 2 and 3, currently the solid concentrates with greater than 60% THC are prohibited. And any oils, except those that are prepackaged in vapes are prohibited. And this is removing those prohibitions.
So serious.
Yep,
Can you just remind me about number 2?
Remind you,
Why that one's going to be available?
I think probably James is better to speak to that, but I think the testimony has been that when you have certain concentrates, that they have a much higher THC concentrate. And if you need to get it below 60%, then you are putting in additives that can be actually perhaps more harmful. And I think there's concern about having to add things in there to bring the level down, but I would defer to James on that.
Okay. Is James, okay, well, maybe come back and ask James.
So,
Okay, thank you, Michelle.
so there's a question about concentrates on page 5. Go ahead to page 7.
yep, page 7. This is the provision on rulemaking with regard, this is the place where we're tweaking the language around opaque child resistant packaging. So now it just need the opaque child resistant packaging for cannabis products and then child deterrent packaging for cannabis. So there's a distinction there when you're talking about the flower. Section 5.
This is all about flour, indeed. Is that correct?
No, cannabis product. That's something that's an infused product, and the current requirement is for child resistant, and that stays the requirement. What's changing is the packaging for flour.
Yeah.
Okay, thank you.
So section 5, and this is the new language with regard to obtaining the background checks. And again, I'm just going to skip over this a little bit if you don't mind, and I'm going to let James talk to you more about how they are planning to address this. But they're, as he talked about before, essentially they're going to this would allow the board to accept third-party criminal background checks submitted by an applicant. So, and then the conditions for that. Page 9, section 6. This is addressing the issue of identification cards based on the record checks. Again, trying to find something that the FBI will okay for us to be doing these checks. Section 7. This is clarifying the language that's in the general licensing statute to make it clear that when the language that's in current law talks about that folks can only have one of each type of license, that subdivision B there talks about the integrated licenses. So clarifying that it's an applicant and its affiliates that control a dispensary that's registered on April 1st, 2022 can obtain one integrated license. So it's trying to true it up with the existing definitions and trying to address any ambiguity that might be read into the existing law, but not intended to change it substantively, but to clarify. And so I added section 8 that goes with that. So little legislative intent, which is identifying that the purpose of the above amendment is solely to make the language consistent with the terms that are currently used in the law and shouldn't be construed to alter the meaning as it was originally proposed.
Good.
Section 9 is amending the retailer provision. And you'll see at the top of page 12, subsection E, that is just striking out the current ban on internet ordering. So delivery would still be prohibited, but you could, just like I go online and order groceries at Shaw's and show up at Shaw's and my groceries are all packed up for me and paid for. It's the same kind of thing.
Okay, Very
And
good.
that's it.
thank you, Michelle.
Sure.
James Pepper, head of the chair of the Cannabis Control Board, comments. I think folks are particularly interested in all of the fingerprinting sections.
I will start there then. This is James Pepper from the chair of the Cannabis Control Board. So the fingerprinting, in order for a non-criminal justice agency to receive fingerprint supported 50 state criminal history records, we need to meet certain standards. And I can tell you that there's about 300 agencies of various types, political bodies in Vermont that receive these records. It's pretty routine. You all know how to do this pretty well. You need to have a statute that authorizes it, and you have to kind of explain who the person that's being fingerprinted is and why the state needs it. You did that very well in Act 164. In fact, I think, Michelle, the definitions that we used are exactly in line with what Colorado and Oregon and some of the earlier states used. And honestly, it was sufficient back then. One of the standards that the FBI has to kind of meet in order to authorize this is that the authorization must not be against public policy. Also, that the authorization must not be overly broad, and it must be specific with respect to who's getting fingerprinted. I think that criteria about public policy has shifted, honestly, at the FBI, because what we're seeing across the state, or across the country, sorry, is that states are being denied this authorization specifically for cannabis, and specifically for adult use cannabis, because it's not happening on the medical side. We've been in communication with a deputy general counsel at the FBI about our authorization. The kind of advice that we were given was get more specific in these definitions of who is a president, who is a vice president, who's a manager, who's an owner, who's a controller. Try your best to cross-reference your corporate statutes. These are terms that are generally understood, and I think that people, at least at the FBI, used to kind of understand them and not make a big deal about them being very specifically defined. But now I think that it's, we're at the point where we need to be more specific. That's the direction we've been given. And we worked with our partners, a deputy general counsel at the Department of Financial Regulation on this language. It doesn't change anything substantively as to who the people are that we're going to fingerprint. It's essentially anyone that has a controlling interest in a company, a financial stake above 10% in a company, and anyone who can kind of exert managerial decisions over a company are the people, and employees. And those are the people that we want to seek fingerprinting, 50 state supported background checks. The FBI will not pre-authorize language until it is in a draft bill. And so while they offered to kind of look at our language and give us a preliminary thumbs up or thumbs down, we don't have that for today. We did, when Michelle finished this draft, we sent the draft to them, and we're hopeful that we're hopeful that this is sufficient as is, because it is in line with what they told us to do. And we hope that we get some clearance from them before the session ends, just in case they say, come back to us But we do believe that this will satisfy the FBI. What you're seeing kind of in the subsequent sections around the notwithstanding section, sorry, I could pull it up and tell you, but essentially we've created a plan B, an alternate path. You wrote in the legislation that we need to get fingerprint supported background checks for all of the kind of principals and owners and financiers and employees. And if it becomes an impossibility, some of the highlighted language that Michelle walked through is our alternative approach, which is essentially not getting a fingerprint supported background check, but contracting with a third-party vendor. It's the same one that Massachusetts uses to do their criminal history checks. And essentially what we're going to require from all of those folks, all of the principals and owners and managers, et cetera, including employees, is a attestation to where you've lived or done business for the past 7 years. And this third-party vendor will conduct a civil, criminal, and administrative law check in those jurisdictions, and essentially get us to the same place, not fully, but get us close enough to a place where we can know exactly who is owning a cannabis license in Vermont, and make sure that no one that might compromise the industry or run afoul of the kind of FinCEN guidance or the kind of underlying Cole memoranda are getting licensed in the state. And I know that that's a lot of information, but essentially I can answer any questions.
James, is this entire bill flexible enough so that if the FBI comes back and says you need to tweak X, Y, or Z, that you could bring it as an emergency rule to LCAR?
Oh,
No. Unfortunately, when I mentioned there's kind of 5 standards for the FBI in order to kind of allow a non-criminal justice entity from receiving these, is one of them is it has to be in statute.
Okay, thank you.
Next question, Joe.
Yep.
So James, I'm just wondering, could you, if you have to go to the Plan B, would you continue to work to get it in statute for next year? I mean, sort of a guarantee that someone will do that. I mean, I think because the number of out-of-state people that might be coming in to apply for licenses or do other things, I think that, and the attestation being, good for some people, lousy for others, that you would continue to pursue exactly to be able to get the real one, the real run through with the FBI next.
Yes, absolutely. And this criminal check happens both at initial licensing and renewal. So if there is a year when we're relying on this kind of 7-year attestation, it would, and we can get authorization from the FBI for next year. At the renewal, we will run the full criminal 50 state supported fingerprint supported check. And we will work, to update the language to whatever the FBI needs us to do. We do have the ability to suspend, revoke licenses, charge fees. And, if you are untruthful with the board, intentionally untruthful, it's an automatic suspension. So people really, and possibly a revocation as well, depending on the severity. And so, people do have a real interest in not hiding the ball with us, our potential licensees. So this process, our Plan B, while not ideal, and takes a little bit of extra time and actually will be an additional cost to the applicant, is something that we think will suffice and provide deprioritize Vermont for federal enforcement, essentially. I mean, the whole reason for fingerprint supported background checks is so that the DEA and the federal government don't want to prioritize Vermont for enforcement.
Okay, thank you.
Okay, other questions on this issue or any of the issues outlined in this bill?
I like the definition of child return packaging.
Yeah, I think that was good work by
Yeah.
Senator Ruth.
Yeah, that was.
And I'm quite frankly very pleased with this. Clarifies our intent on the licensees of the medical marijuana establishments and their
Yeah.
obtaining an integrated license. Is there a motion to report favorably H548 as amended?
Don't we have to? do the amendment
Oh,
first?
right, is there a motion?
I'll move to.
Senator White has moved that report draft, that we amend H548 as seen in draft 1.2 dated 4/14/22. Any further discussion? Senator, Peggy, please call.
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes, you've amended H548. Is there a motion to report H548 favorably as amended?
Yes.
Senator White has moved that we report H548 favorably as amended. Further discussion? Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes, we're unanimous. Would you like to report this, Senator White?
I'll let you do it.
I
mean,
You always do marijuana.
I know.
I mean, do the bill.
I
report
always
the
do
bill on
marijuana.
All right, I
mean, I'm-
just need two
I'm
today.
fine, but I have a bunch that I have
I
to do.
probably got a 3-hour report on H553, by the way.
I have a couple of big ones here.
Yeah.
Is it you, Senator Sears?
Yeah, I guess so. We're all done. Senator Benning has to get up, get ready to.
So, Senator Benning, are you good for the floor?